One handwritten letter, scribbled from a Florida prison cell, completely reshaped America's justice system, guaranteeing legal representation for anyone facing a felony charge, regardless of their ability to pay. Before March 18, 1963, if you couldn't afford a lawyer in a state court, you were often on your own. This wasn't just a legal nicety. It meant thousands faced prison sentences without understanding the charges against them, let alone how to defend themselves. The Supreme Court's unanimous decision in Gideon v. Wainwright didn't just affirm a principle. It retroactively opened prison doors and forced states to establish public defender systems. But the direct implications of that single letter reached far beyond felony cases, subtly influencing every interaction with the criminal justice system that came after. Stick with me, because the final, less obvious legacy of this case is something that profoundly impacts you, the citizen, even today, and it's a detail almost everyone overlooks. Imagine a justice system where you could be charged with a serious felony, face years in prison, and be entirely alone in court, unable to afford a lawyer. Before 1963, for millions of Americans, that was the reality. In fact, over half a century after the Bill of Rights was ratified, the Supreme Court had yet to definitively say that every person accused of a serious crime had a right to a lawyer, even if they couldn't pay for one. That changed with a handwritten letter from a prison cell. This single, meticulously penned document, drafted by a man named Clarence Earl Gideon, didn't just win him a new trial. It dismantled a fundamental flaw in America's legal structure, redefining what justice for all truly meant. Gideon, a man with an 8th-grade education and a history of nonviolent offenses, found himself at the center of a legal earthquake simply because he believed in the promise of the Sixth Amendment. On June 3, 1961, Gideon was arrested in Panama City, Florida, accused of breaking and entering with intent to commit a misdemeanor, a felony under Florida state law. How could one man, with an 8th-grade education and a history of small-time crimes, launch a legal challenge that reached the Supreme Court? Born on August 30, 1910, in Hannibal, Missouri, Clarence Earl Gideon was, by most accounts, a drifter. He had a history of nonviolent offenses, but nothing suggested he would become the architect of a constitutional revolution. That changed on June 3, 1961, when Gideon was arrested in Panama City, Florida. The charge: breaking and entering with intent to commit a misdemeanor, a felony under Florida state law. When he appeared in court without counsel, he requested that the state appoint him an attorney. Under Florida law at the time, court-appointed attorneys were only provided in capital cases. Gideon's request was denied. Forced to represent himself, Gideon subsequently lost his case and was sentenced to 5 years in state prison. It was from his cell, a palpable sense of injustice fueling him, that Gideon began to handwrite an appeal, a journey that would ultimately reshape the Sixth Amendment, a constitutional loophole nobody noticed. And yet, for nearly 2 centuries, a significant constitutional loophole left millions vulnerable in state courts. The Sixth Amendment explicitly guarantees the assistance of counsel for defense in criminal prosecutions, a right consistently applied in federal cases since 1790. However, the legal understanding was that this mainly applied at the federal level, unless a state chose to adopt it, or in capital cases where the Supreme Court, in its 1932 Powell v. Alabama decision, mandated counsel for indigent defendants. For Florida and many other states, this meant an indigent person like Gideon, charged with a felony such as breaking and entering, had no right to a court-appointed lawyer. The prevailing interpretation of the 14th Amendment's Due Process Clause, the critical mechanism for applying federal rights to the states, was that it only required states to provide counsel in cases deemed special circumstances, typically death penalty cases. This created a profound disparity. The core legal question Gideon's handwritten petition forced the Supreme Court to confront was fundamental. Did the Sixth Amendment's right to counsel extend to all felony cases in state courts via the 14th Amendment? How the court would answer this, and if they could do so unanimously, remained an open question. What if the Supreme Court, after 2 centuries, suddenly realized a fundamental right had been overlooked for millions? On March 18, 1963, in a unanimous decision, the U.S. Supreme Court announced its ruling in Gideon v. Wainwright, 372 U.S. 335. This landmark decision held that the Sixth Amendment's guarantee of a right to counsel is incorporated to the states via the Due Process Clause of the 14th Amendment. This meant the right to a lawyer was no longer just a federal protection, but was binding on state governments in all criminal felony cases. The court emphasized that the right to legal counsel is fundamental to a fair trial, making the adversary system work correctly. This ruling immediately overturned Gideon's original conviction and mandated that states provide attorneys for indigent defendants facing felony charges. It redefined a criminal defendant's right to counsel, ensuring lawyers for the poor. The principle established was clear. A fair trial for a man like Clarence Earl Gideon could not exist without the assistance of counsel, but the promise that echoes 50 years later. But what if a constitutional right, so profoundly stated, remains largely unfulfilled decades later? 50 years after the landmark decision in 1963, the ACLU of Pennsylvania's legal director, Whittled Vic Walczak, emphasized that Gideon's promise remains unfulfilled. Despite the unequivocal right to counsel, the reality for many indigent defendants, particularly in economically disadvantaged counties like Clearfield or Fayette, is a system crippled by chronic underfunding. Public defender offices frequently face overwhelming caseloads, with some attorneys managing over 500 felony cases annually, far exceeding national standards. They struggle with insufficient investigatory resources, limiting their ability to interview key witnesses or fully examine crime scenes, and high rates of attorney burnout. For instance, a 2017 study by the National Association of Criminal Defense Lawyers revealed that public defenders in several states report spending less than 6 minutes per case at arraignment, barely enough time for a meaningful conversation with their client. This chronic under-resourcing leads to a critical consequence. Many indigent defendants still receive inadequate representation, a factor contributing significantly to wrongful convictions and unjust sentences, often disproportionately affecting minority communities. Walczak underscored the enduring significance of this constitutional right, describing it as an emergency protection for individuals, vital even if its full realization remains a continuing struggle. This begs the question: how is Gideon's legacy still fighting for justice in 2026? Over 60 years after Gideon v. Wainwright, has the promise of a free lawyer for the poor been fully realized? Despite the monumental 1963 ruling, challenges to guaranteeing effective counsel for indigent defendants persist. The issues are systemic. Public defenders in some jurisdictions manage caseloads 2 to 3 times the recommended national standards. This means a public defender might have only minutes to review a client's case before a critical hearing, far from the ideal envisioned by the Supreme Court. If Clarence Earl Gideon were arrested today, charged with felony breaking and entering, would he truly receive the effective counsel the Supreme Court envisioned? The spirit of Gideon's handwritten petition, arguing for the right to counsel for the poor, still resonates because underfunded public defense systems can leave defendants with minimal representation. As March 18, 2026, marks another anniversary, it's a crucial reminder. Gideon v. Wainwright isn't just history. It's a living constitutional principle whose full promise still requires vigilance and reform. This video presents publicly documented information for educational purposes, not legal advice. So Gideon v. Wainwright was not merely a judicial decision. It was a reaffirmation that the principle of equal justice under law must extend to every individual, regardless of their economic standing. While the Supreme Court's unanimous declaration in 1963 was monumental, the consistent underfunding and overwhelming caseloads faced by public defenders mean the promise of an effective defense remains a daily struggle for countless defendants in 2026. This case, therefore, serves as a crucial reminder that the constitutional right to counsel is only as strong as the system designed to uphold it. Have you or someone you know encountered the public defense system? Share your experiences in the comments below. To continue exploring how landmark legal decisions shape our contemporary justice system, subscribe to the channel. And if you found this analysis insightful, my breakdown of Miranda v. Arizona and its ongoing impact on police interrogations is exactly the next thing you should watch. This video presents publicly documented information. It is for educational purposes, not legal advice.